May please, Your Lordship. Your Lordship, I beg to mention item number 5 of the hearing list, Your Lordship. Your Lordship, in this matter, I'm being led by Mr. Shulai, and he's unavailable today, Your Lordship, on...
I'm for the petitioner.
Any objection?
No, Your Lordship.
I'm for the second respondent, NDC.
On pre-made by the state respondent on the ground of personal difficulty on the part of the Leonard AG, the prayer for a genuine, not being objected to by petitioner, is allowed. This is matter up to 2 weeks.
Obliged, Your Lordship.
May it please, Lordship. Lordship, I beg to mention item number 6, Lordship. Lordship, kindly have this matter after 2 weeks, Lordship.
I think they are not so much interested. I think it may be listed after 4 weeks, Your Lordship.
2 weeks, Lordship. Senior counsel is on sanction leave, Lordship.
On pre-made by the petitioner, this is matter up to 2 weeks.
Highly obliged.
Please, Your Lordship. Lordship, I beg to make a mention item number 3, Your Lordship. Lordship, in this matter, if I may pray for a fixed date, Your Lordship.
I think we have made it clear that this will be the date that we will hear this matter.
Lordship,
in fact, this was on the request of your senior.
Lordship.
Has this matter been heard?
No, my lord.
It was not part heard.
It was only petitioner only made certain submissions just to let the background of the case. Otherwise, there was no hearing from both sides.
Lordship, if I may pray that this matter may be listed on Tuesday, Your Lordship.
No, not on Tuesday.
Today's 16.
16.
Yet again, accommodation has been sought for on behalf of the petitioner. It is to be pointed out that this is a very, very long pending matter of 2015. It appears that the petitioner is not interested to pursue the matter. However,
Lordship, here what happened, private respondent, the property holder,
Number 1.
Prabhashini Datta, she has expired, and thereafter the family members has already given a power of attorney to their legal one son, one of the brother, but he also expired recently in the month of February. So I was under instruction to appear for respondent, but since both the power of attorney holder also expired, I cannot file my power. And the Prabhashini Datta, against whom the case was instituted, she also expired. So now
nothing remains.
pardon.
Nothing remains.
No, Your Honor,
They
here
have not been substituted.
they have not been substituted. Now, Your
Are
Honor,
there any other legal heirs?
yes, the one sister. There are 4 brothers and sister. So one brother expired. So after finishing the last rite and rituals, they will be coming forward, Your Honor, because now they are under the they are about to complete.
These things, I think observation has been, I don't know whether it is on record or not, but observation has been made that the since the death of course the death is known,
Yes.
no one has come forward, so matter has proceeded to the extent that it will proceed only against the other respondents.
That is the deputy commissioner.
The deputy commissioner. So now you come at this stage and say this.
Okay, Your Honor, if because the main order of the Deputy Commissioner is challenged.
Yes, so if it does not materially affects you
Yes.
or the party for that matter, then we will let it go and let the matter be disposed of. Because I think this is with regard to some order passed by the Commissioner of Revenue.
Revenue.
Revenue Board.
Revenue Board, yes.
Revenue Board.
So,
Initial order was by the Deputy Commissioner. Against that order, they have gone to the Revenue Board. Revenue Board has passed the order against the petitioner. And so the revision
and
is...
yes, and it is a, sorry, yes. It's a revision petition.
Yes, revision petition. We have already appeared there in the
Revision
Revenue
petitions,
Board also.
You see, what the court requires is only to go through the records.
Yes, Your Honor.
And only issue of jurisdiction, propriety, impropriety.
My lord, if I may suggest, my lord, justice will be met if the matter is granted 3 weeks time. In the meantime, if they can come up, let them come up with appropriate petitions. Court may consider or reject it. Otherwise, more time.
In that way, see.
Because either way, even if the order is passed, they can they can assail the order at any stage.
Let them go as long as we dispose of this order.
Insofar as we are concerned, we are already determined that we will proceed with the Deputy Commissioner and the petitioners. Because they were the initial complainant, upon which the Deputy Commissioner took cognizance and the registration was cancelled. That is what the case started.
Your Honor, if since Revenue Department's order is in my favor, because the only thing is that means the legal eye should come forward, because if it is, since it is in my favor, and I though I have expired, but my legal eye is still there.
This involves a lease or
Yes,
what is it?
Yes,
this
this
involves
involves
the
a
land
lease.
in RR colony.
Because land means
Yes.
ownership to the land,
Pata.
lease or whatever. Because it's a we know the the special category that the land holds.
Correct, ma'am.
Let the matter come up as pass. See order. You make a submission then.
We will wait.
My lord, item 7, Your Lordship. Lordship, this matter will be for 2 more weeks accommodation, Your Lordship.
On pre-made by the petitioner, this is matter of 3 weeks.
Your Lordship.
Supplementary cost list, item number 1.
Your Honor, I am here for this bail application, anticipatory bail, Your Honor. Your Honor, here what happened, this bail application is filed for the accused person. The brother of the accused person has filed this application, and he is medically, he is not fit, Your Honor. Even he is in ventilation in Ningrims. So
who's in ventilation?
the accused person. So he, if the family of the accused person wants him, since here the no one stays, no one of the they are like they are coming here, and it is more the expenditure is more.
Where is the medical report?
Medical report is annexure 2, Your Honor. Page number 13, Your Honor. The last part of the medical report, it says that he was gradually weaned off ventilator and shifted toward. 2 weeks after the surgery, he developed features of sepsis and wound infection. The last part of the medical report, Your Honor. Lordship. May I, Lordship? Lordship, here, since it is under means the treatment, he is in ventilation, and the treatment here has gone in stagnant way, because 91 days today, it is more than 91 days he is in same condition in ventilation only. So there are
But this is a report of 31st January.
31st January, but
So we don't know
till
what is
now,
the
till now,
present condition.
the present condition same, Your Honor.
No, you should have got the latest report.
Latest report
Now we are in February. You
February.
should have got the latest report and to know.
Lordship, because the doctor has stated already in this report that means the condition is same, Lordship. Whatever the condition is, he's still under ventilation, Lordship.
Or Ms. V. Purchari, learned counsel for the petitioner. Mr. To appears for the state respondent. Before proceeding with the merits of this case, the case diary of Teriat PS case number 9011 of 2023 under section, IT section 1, is required to be produced before this court. Let the same be produced on the next date fix. In the meantime, the accused person, Shri Shakil to Mahbub Sheikh, is allowed to go on interim bail on condition that he shall not abscond or tamper with the evidence and witnesses, as submitted by the legal counsel for the petitioner, that the medical report of the medical status of the petitioner be produced on the next date fix. This is matter on 4th March.
Item 2.
Mention means I'll inform the court. Lordship, items number 2 to 5, Your Lordship, are connected matters arising out of the same police case, Your Lordship. So these 2, 3, 4 have been endorsed to others, but they have requested me to lead. I am in item number 5, Your Lordship.
These are bail matters?
Bail matters.
Bail matters, madam.
NDPS case.
NDPS?
Yes.
Section 37 involved?
No, my lord.
Intermediate?
Not only, my lord, of course,
It's intermediate.
I have been charged under intermediate, but my submission would be this is a case of small quantity, my lord. I'll come to that.
See, those are all matters of investigation, not...
No, my lord, this is a settled position of law, my lord. My lord, I am moving this bail application on 3 grounds, my lord. Firstly, my lord, this is a case of small quantity. Secondly, my lord, the alleged narcotic substance, my lord, was never recovered from me. Never recovered. May I? First of all, 1st May 2023, my lord, the police of Barneyhat PS, my lord, outpost, my lord, they received some reliable information, my lord, and they conducted a NACA, my lord, and thereafter at somewhere around 9:30 p.m., my lord, a local taxi is being stopped, and police on checking the local taxi, they find a driver and 4 passengers, my lord, all young passengers, my lord. Now thereafter, my lord, search was conducted, both physical search, my lord, as well as the search of the taxi, my lord. On physical search, my lord, nothing was found from the 4 accused person here, my lord. On being taxi being searched, my lord, inside the dashboard, police allegedly found a soap case, my lord, containing some suspectedly, my lord, contraband. Later on, it was found, my lord, that it was 9.15 gram of suspected heroin, my lord. That was retrieved from the dashboard, my lord. And my lord, shockingly, the police did not arrest the driver, my lord, of the local taxi. And passengers were illegally shown to be arrested in this case, my lord. Now, what has happened, my lord? Firstly, my lord, I'll say that I had no knowledge. The passengers, the 4 passengers had no knowledge about the, my lord, that soap case is being in the dashboard, my lord. Under section 54, my lord, of the NDPS, my lord, the law, the position is very clear, my legal position. That presumption arises, my lord. Presumption is to my knowledge of the contraband being kept in the dashboard. But my lord, for that, in order to attract this presumption, my lord, I respectfully submit, my lord, that first, the seizure should be from my physical presence, my lord, position, my lord. On that point, my lord, I am relying on the latest Supreme Court judgment up to 2022, my lord, that is reported in 2022 SSC 9 Supreme Court, page number 1.
What is the stage of the case?
My lord,
What is the stage of the case?
my lord, we are in the stage of, my lord, PWS, PW1, PW1, my lord, we have already examined, and he is the seizure witness. The complainant could not be, my lord, examined here because he is the police officer and he is on training, my lord. So I am waiting for the complainant, my lord. That is the stage. Now here, my lord, I am relying on this Supreme Court judgment 2022 Supreme SSC online SC 1117. My lord, the relevant,
Have you any, firstly, let us go.
my lord.
You have annexed all the relevant papers.
Yes, my lord. The charge sheet has been.
Charge sheet and the
Charge sheet is annexed, my lord.
deposition of the PW1.
So,
Deposition of the witness who have been examined.
that is not there, my lord. This is the charge sheet, my lord.
That would be, it would be better. So the
But
court can
seizure witness, only seizure witness has been examined.
only say witness.
Only seizure, my lord. And I'm not disputing that, my lord. Kindly. My lord, here, my lord. Relevant paragraph would be 34, my lord. If I may, my lord.
Yes, just wait.
It is true that Section 54 of the Act arises a presumption, and the burden shifts on the accused to explain as to how he came into possession of the contraband.
Paragraph.
Paragraph 34, my lord, last page, my lord, last page. But to raise the presumption under Section 54 of the Act, it must first be established that a recovery was made from the accused. The moment a doubt is cast upon the most fundamental aspect, namely the search and seizure, the appellant, in our considered opinion, will also be entitled to the same benefit as given by the special court to the accused. In view of the above, we are of the considered view that appellant is also entitled to the benefit of doubt. Therefore, the appeal is allowed. The judgment of the special court so and so. So, my lord, this is a case, my lord. This is not even a case that when my person was being searched, my lord, nothing was recovered. That is the finding, my lord. So it is from the dashboard. So therefore, my lord, presumption cannot be, my lord, shuttled on me, my lord. Now, second ground would be, my lord, this is not a case of, my lord, when a contraband is seized, my lord. For example, in this case, my lord, it is allegedly is heroin, my lord. Supreme Court and all the high courts of the country has come to a consensus view, my lord, that it is not the total seizure, my lord, of the contraband that is taken into consideration. It is when the FSL report comes, my lord, what is the percentage of the contraband there, my lord, that is taken into account, my lord.
But that would be, that would not be in consonant with the Tofan case.
My lord, is Tofan case. It is also there, my lord. I have got latest Supreme Court judgment here, my lord. That says, my lord, it is the content of the, my lord, the alleged contraband that is taken into consideration, my lord. So here, as per the FSL report, which is at page, my lord, kindly come to my lord, page. My lord, page 28, my lord. 28. That is the FSL report, my lord, page 28. The last part would be result of examination, my lord. The exhibit marked so-and-so gave positive test for the presence of diacetylmorphine and his percentage is 17.5764%. So, my lord, the total contraband, my lord, that was seized from me was 9.64 gram, my lord, and 17.57% comes to, my lord, 1.69 gram, my lord, which is very below the small quantity, my lord. So, my lord, I am relying on the Supreme Court judgments, my lord. This is reported in 2008, volume 5, SSC, page 161. Head note, my lord, head note number C, if I may read, my lord. Narcotic Drugs and Psychotropic Substance Act 1985, Section 21, quantum of punishment under determination of whether contravention involved in the instant case was small, intermediate or commercial quantity. Also, whether total weight of substance was relevant or percentage of heroin content translated into weight was relevant for ascertaining the quantity of the quantity recovered from the accused. On facts, total quantity of contraband article seized from the appellant was 4.07 gram and purity of heroin was 1.4% and 1.6% respectively in two samples. As per central government notification dealing with heroin, small quantity is mentioned as 5 gram and commercial quantity is 250 gram. Punishment would vary depending upon whether quantity of offending material is a small quantity, commercial quantity or something in between. Hell, intention of legislature was to levy punishment based on the content of the offending drugs in the mixture and not on the weight of the mixture as such. Hence, it is not the total weight of the substance recovered that is material, but the percentage content of narcotic drug translated into weight that is relevant. In the instant case, the heroin found in the possession of the appellant as per the analysis report was about 60 gram. After translating its percentage content in the mixture into weight, which was more than 5 gram, that is a small quantity, but less than 250 gram. So here in this case, commercial quantity was converted into...
No, this Michael Raj case was, I think this was overruled, if I'm not mistaken.
My lord, I am coming to that. This is in
as far as the measurement to be taken is concerned, quantity to be concerned. Yeah, here it says that only that part of heroin,
my lord, yes,
which is found in the substance to be taken. But I forgot what is the later judgment which says that the whole mixture has to, or substance has to be.
Lordship, I bow down to that. However, my lord, be that as it may, my lord, the first ground I have taken, my lord, it was never, my lord, retrieved from my person, my lord, but it was from. Secondly, my lord, I was arrested, my lord, way back, even more than nine months back, my lord. I was arrested in 1st May of 2023, my lord. We are young people, my lord. We have been languishing in jail. It is charge sheeted, my lord. And PWs are not being examined because they are in training, my lord. So on that ground also, my lord, I respectfully pray, my lord. We have no criminal grounds, my lord. So therefore, my lord, my bail application may be considered, my lord. On any strictest condition, my lord. Highly obliged.
Please, Your Lordship. My friend here has been emphasizing on the fact that no contraband item was seized from their possession, Your Lordship, but they were traveling in a vehicle, Your Lordship, and the soap case containing the contraband item was found in the dashboard, and there were 11 syringes and 4 vials which were found at the back seat, passenger seat, Your Lordship. And then on investigation and questioning, Your Lordship, interrogation, it was, these people have admitted that they were carrying the drugs and they were the ones who had hidden it in the dashboard, Your Lordship.
That is there in,
Yes, Your Lordship. In the course of investigation, this was revealed, Your
in their
Lordship.
statement and
In the statement before the
161
police,
statement.
under 161, not 164, Your Lordship, under 161.
161. Accused would
161,
be 161.
yes, Your Lordship. This is what was revealed by them, Your Lordship, which is why they were arrested, Your Lordship. And as far as the purity of the content, that, as Your Lordship has pointed out, there are judgments which shows that the entire amount seized has to be taken into consideration and not only the percentage of the mixtures therein, Your Lordship. So my humble submission is this, Your Lordship. These boys may be consumers, they were also trafficking, because from the statement, Your Lordship, I could gather that they were obtaining and they were purchasing and selling drugs, Your Lordship. So if they are released on bail, Your Lordship, the same thing will go on again. And it is in their best interest that they are in jail so that they are weaned away from their habit, Your Lordship. This is my humble submission. So they may not be granted bail at this stage.
Have they admitted that they are consumers of the
In 161, they have admitted they are consumer, my lord.
If that is the case, as Madam said, it would be in the best interest to be.
In
If they are in custody, it is almost like
Again-
being in a rehab.
yes,
That would be for their.
in their best interest.
That is there, my lord.
That is beside the point. We are not.
I think, my lord, 9 months, more than 9 months is, my lord, it is more than sufficient, my lord, to, my lord,
They are going to come out
So,
and
my
they're
lord-
going to indulge in the same activity again and again.
my lord, it is a matter of right, my lord, when it comes to consumers, my lord, if they wants to go for seek help, my lord.
You know very well, Mr. Guru. Right has to be way. See, as far as individual right is concerned, vis-a-vis societal rights,
Correct.
the rights of the general public, of innocent.
That is absolutely correct.
Innocent victims. You know very well. You know the
My
scene.
lord, this is absolutely correct.
And they're young.
I'm on the
boys.
ground, my lord. Nothing was seized from me. How can this local taxi is a public conveyance, my lord? So I can't be expected to know what is there in the vehicle,
They've
my lord.
admitted that it
I'm
is
a
their-
simple
their-
passenger, my lord.
It is
Where is
theirs.
the statement under 161?
Syringes were found, vials were found at the back seat, Your Lordship. You must have been indulging in that.
Where is this?
In the FIR, it is written, Your Lordship, that there were 11 number of syringes
Fire is a different thing.
and 4 empty vials at the back. Then
Have you annexed their statement?
statements are there, Your Lordship.
It is there, my lord. My lord will come to page 24.
24.
24. Kindly come to the last paragraph, my lord. Can I read, my lord?
Just yes. Yes, madam. Anything else?
Your Lordship, that is all, Your Lordship. Forward swiftly, I mean, if Your Lordship may have gone through the statements, they are all in collusion with each other. They met in Birmingham, they have purchased, they have consumed the drugs, and they were proceeding towards Longport, Your Lordship, when they were intercepted by the police on receipt of reliable information, Your Lordship. So my humble submission is that at this stage they may not be released on bail.
How many witnesses are there? Prosecution witnesses?
There are about 9, Your Lordship. 9 of them at page 23, Your Lordship. One has already been examined, so little left. Independent seizure witnesses will be there who are from the Shnong and the officers.
Yeah, they've been in jail for quite some time.
That is
Yeah,
correct,
young.
Your
Let
Lordship.
him go. Heard Mr. Argun, learned counsel for the petitioner, who has submitted that an FIR dated 2/5/2023 was lodged before the officer in charge, Nongpo Police Station, wherein the informant has stated that the informant, who is a police official of the Birmingham outpost, Ubai district, has stated that on 1/5/2023 at about 7 p.m. on receipt of reliable information, a Naka checking was conducted, and accordingly one vehicle bearing registration number ML10C4908 was intercepted. Where was it intercepted?
My lord, at Umling check gate.
Intercepted at Umling check gate. On a search and seizure being made, alleged contraband substance was seized from the dashboard of the was found from the dashboard of the said vehicle, wherein how many passengers were there?
4, my lord.
4 persons who are said to be passengers of the said. It was a taxi.
My lord, local taxi.
Local taxi.
Where are suspected to be in possession of contraband substance, which substance on being tested would reveal that it contained heroin. The weight of the suspected drug is 11.96.
It's 9.64.
9.64, Your Lordship.
9.6.
4.
4.
Minus the
minus the
cover, the plastic.
container, yeah, 9.64 grams.
That's the intermediate quantity, Your Lordship, not small quantity.
Accordingly, on investigation being launched, all the four suspects have been
Arrested.
My lord, yes.
the said four passengers of the
Taxi. Your Lordship.
local taxi were arrested. In due course, charge sheet was filed by the investigating officer who has found that a prima facie case is well founded to proceed against the said accused person under the relevant provisions of the NDPS Act. I full form to particularly section
21B, Your Lordship.
21B/29. The case is now at the stage of evidence where one witness have been examined. Out of the total 9 witnesses cited have been examined. And the Land Council has something that the seizure of the alleged drugs was from the dashboard of the said local taxi, and as such it cannot be presumed that it was found from the possession of the accused person. Should we take it? Should I pass a common order or should I?
Yes, common order.
Common,
Come.
because it arises from the same case, Your Lordship.
So I have a common order from the accused persons. No. Reference to the applicability of section 54 of the NDPS Act was made with the case of Sanjit Kumar Singh alias Munna Kumar Singh versus State of Chhattisgarh being cited in this regard. The same reported in 2022 SCC online SC 1117, wherein at paragraph 34 of the same, the Honorable Supreme Court has observed as follows. Quote, the next point of contention raised by the learned counsel to the petitioner is that the alleged seized contraband drugs though indicated as intermediate quantity is actually not so, but in fact it should be noted as small quantity. In support of this contention, the learned counsel has led this court to the, where is that FSL report?
Official report is, my lord.
At page 28, Your Lordship.
28. Led to the report of the FSL examination of the seized contraband drugs, wherein where is the indication here that the 9 grams were taken as, nothing is said here that,
No, not,
My lord,
nothing is said here as to how, what is the quantity that was, tested.
sorry, my lord.
Nothing is said here as to what is the quantity that was tested.
Is there, my lord, the last result of examination?
That is the result. Eh? See, it says percentage is 17 point.
17 point.
Out of what?
Out of the, my lord, the sample that was sent to the FSM.
Where is
but
the,
it's not indicated, Your Lordship.
should be, that such and such amount was sent to me. I have examined,
And
and
out
then
of
found
this,
that percentage was,
That is there, my lord, that is there.
it should be in this.
However, this percentage will apply on the entire alleged.
True. But even then, that should be an indication here. One transparent polymer will containing orange color powder weighing
5.6664 gram.
5 grams is usually the sample that is
Yes, ma'am.
usually taken.
Yes.
Yeah. Kuning toko? Wherein out of a sample of 5.6664 grams, when tested, it gave a positive test for the presence of
Acetylmorphine.
morphine, the percentage of which comes to 17.5764%. It is the contention of the learned counsel for the petitioner that 17.57% of the 9 grams,
9.64 grams.
9.64 grams seized would reveal that the actual contraband substance
Would be 1.69.
actual drugs, is it heroin, isn't it?
Heroin.
The actual quantity of heroin seized would be
Reduced.
1.69 gram.
1.69 gram.
Is it out of 5 grams or 9 grams?
Entire,
You've calculated entire. Because
Percentage, no? It is by percentage.
because this percentage 17.5764 has come out when they
When they
tested 5.664 grams. So when they test 9 point, so whether it
Percentage
would be
same.
1 gram or
Yes, yes.
more than 1 gram, we cannot see
My lord,
because I have not calculated
I have
that.
calculated, my lord, 17.
From 9 grams,
Yeah,
you have
from 9.64 gram.
How can it be? You see, if 9.64 is 100%,
Yes.
17% of that,
Would be 1.64.
1.64. I'm not
anyway, that is
69.
calculation.
1.69.
that would be a matter of evidence, or
Argument, Your Lordship.
I have done it, my lord.
because I don't recall, nobody can help me with that judgment also. You should have brought out the judgment.
I can bring Your Lordship if I'm given. You can. Have you got that?
Anyway, I will not dwell on that part. Considering the fact that the accused person in question are
We'll just get that citation.
if you can get it now,
No, we're getting it now, Your Lordship.
our young person in the age group of 20 to between 20 and 30. Some of them are 26, some of them are 22.
22.
And also the fact that they have been in custody for about
Yes, more than 9 months, 16 days.
9 months or so. It is prayed that this court may be pleased to allow this petition and to grant the prayer for enlargement on bail with any condition as deemed fit and proper to be imposed. Where contra, Ms. Tiangi Laret AG, appearing for the state respondent, has submitted that the fact that the contraband substance, that is heroin, was seized from the car in which the accused persons were traveling, and also found not only from the dashboard but also on the back seat of the said vehicle. It can safely be presumed that the accused person were in possession of the said contraband substance. What was the other ground?
The other thing that in course of investigation they have admitted that they
Yes. It is also submitted that in course of investigation all the accused person, all the accused persons have admitted firstly to have been consumers of drugs and also dealing in the area of peddling of such drugs. In such circumstances, if the accused person in question are allowed to be enlarged on bail, there's always the possibility that they will resume their activity in consumption of drugs, and more dangerously in peddling of drugs, which would pose a threat to societal interests. Those are the two main grounds.
Yes, Your Lordship.
It is therefore prayed that these petitions are devoid of merit and the same may be dismissed. This court has considered the submission made and is of the view that the matter is, since the matter is proceeding for trial, any reference to the factual and evidentiary process would not be proper at this stage. However, suffice it to say that upon investigation, the IO has found enough evidence to compel the accused person to stand trial, and as such the issue of the accused has to face the trial till its conclusion. As to the contention as regard the issue of presumption as pointed out and the authority cited in this regard, this court feels that it is too premature at this stage to come to any conclusion on such issue. And also as to the contention that the seized drugs are or is of small quantity as opposed to the finding of the IO that the same is of intermediate quantity, this argument is also not tenable in the light of the Apex Court judgment in give me that.
It's too funny. She's bringing it, you know.
Ay to ka wherein to ka sa ay to ka. However, considering the fact that the accused person have been in custody for quite some time, and also the fact that investigation has been completed, the charge sheet having been filed, and evidence is ongoing, only 1 out of 9 witnesses having been examined so far, the possibility of the trial being concluded within a short span of time from date is remote. It is also to be noted that as far as bail is concerned, the only assurance that the court would seek would be that the accused person should not abscond, and that he or she should cooperate with the trial.
In fact, Your Lordship could fix a fixed term or time limit for completion of the trial.
That would not easy. More often than not, we don't do that because that would put unnecessary pressure on the
courts.
Because they also have other cases too. If you see that, of course, you see, even in POXO cases, the law says one month.
Yes.
Where is that 1 month?
True.
Sometimes it goes up to 1 year, 2 years, but this is not a strange phenomena here. It's all over India. So, usually higher courts should consider.
I'll leave it to Your Lordship because
I was once upon a time I was also there, so I
My lord,
understand.
yes.
Though if it is if the delay is very inordinate, naturally. But let's give it a.
it has
time
just
span of-
started, Your Lordship. And one witness has already been examined.
Let's hope by. That's why I will not give any opinion on that. But hopefully by the next 2 or 3 months it should be. And if they are found guilty, then they will go back. If not, no to go. In this regard, reference can be made to the case of Sanjay Chandra versus Sai Kadumo to the citation to the para 21-22. Thanks. on the overall consideration of the matter, this court is inclined to allow the prayer made. The accused persons are accordingly directed to be released on bail on the following condition.
And they should not be allowed to leave the state, Your Lordship, without permission from the court, Your Lordship. Because that absconding is there, Your Lordship, but to leave the...
Yeah, that is always one of the conditions. You know? They should not leave the state. They should not.
That is, but should not without permission. If that is
standard
specifically
condition.
mentioned, Your Lordship, perhaps
Yes.
will not.
That they should not abscond or tamper with the witnesses. That they shall not leave the jurisdiction of the state of Meghalaya without prior permission from the trial court. That they shall bind themselves. I think there's a common judgment, so it will appear, they shall personally bind themselves on a bond of 50,000 with one surety of like amount to the satisfaction of the trial court.
50,000 each, Your Lordship, or for all of them too?
That's what I said.
Each.
Personally.
Each.
Personally means each.
Yeah.
Bail is not to be taken as a, as a
punishment.
Group, as a group. It will apply to each person individually. The only thing here is because it's a common.
It's common. That is why.
That they shall cooperate with that they shall appear before the court as and when required. The above this set of petitions are I will make the necessary.
Deeply obliged.
We release item number 1.
Your Lordship, IDF for respondent number 12.
Yes.
May it please, Lordship. Lordship, as per the last order, we're supposed to file an additional affidavit bringing on records the certain development, Lordship. However, Lordship, we are contemplating to file a new writ petition challenging that Section 19 notification, Lordship. So,
you're withdrawing this?
Lordship, as of now, Lordship, we are communicating the parties, Lordship, the interested parties. So I humbly pray that let this matter come after 2 weeks, Lordship. Then
This is a border fencing thing.
Exactly, Lordship.
Yes, yes, sir.
You're for NBCC.
I am from NBCC, Lordship.
Learned counsel for the petitioner, Mr. has submitted that instructions are required. Instructions has submitted that the petitioners are contemplating to file a related application as far as the issues involved herein is concerned. However, specific instruction in this regard, particularly with as far as the conduct of this case is concerned, has not yet been received. It is prayed that sometime may be allowed or such instructions to be received and to place the same for this court. On payment, seems allowed. This is matter of the
2 weeks.
2 weeks.
Deeply obliged.
Item number 2.
Lordship, this is a similar matter, Lordship. And as per the last order, Lordship, we have already served a copy to the council, Lordship.
Yeah, Your Lordship, I have received the copy and the draft has been sent for approval. So approval is yet to come from the concerned corporation. So in the meantime, whatever, being the officer of this court, I would like to state that no border fencing work is being carried out. Only the border roads have been carved and they are being, that is what is going on there. No border fencing is been going on. I'll place that on record because there are many.
And the states also are yet to file the affidavit.
Please, Your Lordship.
So you file your affidavit, then? Your counter. All the parties have not filed.
Not yet.
No, not filed.
Except the union lodged. The union said that they have already filed in the other matters, which will suffice. They said they will not
Only if
file
the matters
any.
are taken up together, then you see you can connect the two.
They're
But
not
if they are
connected,
taken
but
up
then they are similar.
independently, then you have to file.
Lordship. But as per the submission in the last order, Lordship.
Anyway,
Lordship, respond number 8, as per the order dated 20/12/2023, we're not filing our affidavit. Respond number 8.
Ms. Airwala GA has appearing for the state respondent has submitted that the counter affidavit could not be filed today and spread for some more time for the same to be filed. Similar prayer has been made on behalf of the respondent number 9. That's 9. You are 9.
9, Your Lordship.
Katumanere 3 to 7. Oh. As far as respondent number 8 is concerned, it has been the learned counsel Mr. has reiterated that no counter affidavit would be filed by this respondent. Mr. Debna?
Earlier, Sir Muzika appeared, Lordship, in the last.
No, now you are appearing in this case. Mr. R. Debna and the CGC has submitted that as far as respondent 1 and 2 are concerned, as far as the respondent Union of India, 1 and 2 is concerned, he also instruction is required to be sought for, which sometimes wait for. On pre-meet, parties are allowed to file their counter affidavit within the next date fix. It is to be noted that the learned counsel for the respondent number 9 has submitted at the bar that as on date, no border fencing has taken place. And you said only what construction?
The border roads, Your Lordship. The border roads have been carved.
However, only the border road has been
carved.
Carved out. As prayed for, this is matter up to 2 weeks. Yes, you give him.
Already served in the before the
Give
last
him an extra
council.
copy. Let him pay for the photocopy.
Sure, Lordship.
What is there?
Yes.
Fine.
Highly obliged.
Highly obliged, Your Lordship.
Item number 3.
I'm praying if this matter can be taken up on Tuesday, my lord. Mr. Paul has requested to list this matter on Tuesday, my lord.
Ms. Bhattacharya wanted to make a submission.
My lord.
So we'll note her submission.
My lord.
Lordship, once I receive, at least 4 weeks time may be given, Lordship, because once I receive my power of attorney, because let them come out from the bereavement and.
Which respondent, my lord?
Respondent 1.
Respondent number 1 has, my lord, by order dated 25/7/2023, my lord. The respondent number 1 has already been deleted, my lord. So they have to file a proper application for that.
That's why that's why earlier I had vaguely recalled about that. So I was telling informing the council that this perhaps have been.
My lord, the
So in
respondent
that
number
case,
1.
you have to file an application then. And if there are other legal heirs who wish to contest the matter, then you have to, in that application, file their name.
Lordship, then Lordship, let it come after 4 weeks because they are under bereavement. Let them come out.
It does matter. But this 2015 matter, why should you?
Pardon, Lordship?
I mean, 2015 matter.
Yes, Lordship.
not delay the matter for so long.
Let them because power of attorney holder was already there. I was supposed to file a petition, but
You see, power of attorney will die with the
yes,
with the executor only.
he expired. So since he also expired, two subsequent deaths in the family, it's like now it is difficult for them also to come.
Exactly, we understand that, but then when the matter was caught up, Ms. P. Prasadi, learned counsel, has made a submission that in this case, the respondent number 1, who has since expired, was survived by other legal heirs, one of whom holds the power of attorney executed by the said deceased respondent number 1. However, in due course, the said power of attorney holder has also expired. Do you know the date?
In the month of February only. I don't know the date.
Month of February means last year.
This month
has also expired recently in the month of February. In the month of February, I recently. This being the case, the Learned Counsel, who has been verbally instructed to appear before this court, would pray that some time be given for an appropriate application to be filed, particularly as regard the order dated
25/7/2023.
25/7/2023, wherein the name of the respondent number 1 was deleted from this record. On prayer made, the same is allowed. Let steps be taken accordingly. This is matter up to 4 weeks.
Item number 4.
Lordship, let it be in another day, Your Lordship.
It's only not even 2:30, not even 12:30. You are already feeling sleepy. What is this matter about, Mr.?
This is the matter, Your Lordship, this regarding promotion, and then during the pendency of the petition, already he got the promotion.
But why I'm praying is from the date I was superseded, Your Lordship.
You have not considered that aspect.
This aspect matters, I need some instruction in the matters.
You see, if you have given him promotion, which means that he is qualified.
Yes.
So in that case, it's just a question of the period.
They're relying
They're
relying on an uncommunicated ACR. That is why I was superseded by a junior. This is the second round of litigation. The first round of litigation, this honorable court has directed the Union of India to supply the ACR. Thereafter it was supplied, and thereafter we filed another representation for reconsideration, not to take the ACR into account when it's not been communicated to me. Thereafter they passed a speaking order. Now in the speaking order, there's no finding as to why I have been rejected, number 1. Number 2, there was no warning. And number 3, surprisingly, they're saying that if we give you promotion, it'll be a floodgate for others.
No, but now eventually they have given him promotion.
Your Lordship.
Eventually they have given him.
They have given me, but by a subsequent date. But my case is that I should be given from the date that I was superseded, from 2019. I've been given promotion only from last year, Lordship. But my only ground at this stage, your Lordship, is that they cannot say that we cannot give you promotion because there will be a floodgate.
No, that is it.
And that I have a judgment where there is a direct violation of my rights.
There is no, you cannot,
At the most, this
on that
court
line.
can come to a conclusion saying, like, whatever promotion granted to me will not be a precedent for others. That is my.
So you have got the hint. It's up to you. You take instruction, and if you can solve it departmentally, do it.
Because I have some Supreme Court judgment on floodgate. They cannot do this. For one person, you're denying one person because of others.
So how long?
Maybe 3 weeks.
Mr. Artevna, Land Council, Land CGC has submitted that he may be allowed to seek instruction as to how to proceed in this matter, particularly in the light of the fact that the petitioner herein has since been promoted, though only in the year. When was he promoted?
Lordship.
When was he promoted?
If I'm not mistaken, on May of April 2022.
Only in the year 2022. On submission made, the prayers allowed. This is matter up to 3 weeks.
Obliged.